Hey everyone. I have got an update to Mr. Carter. He was a handful the first time we saw him, and he went pro se to defend himself against his former employers who he reportedly stole like all of their business equipment. I tried to condense the case down, and I'm not even sure how to do it. So, and if you want to watch the whole thing, I'll put a link in the description. It is 2.5 hours long. I highly recommend watching it on like 1.5 speed because there is so much dead space. And this lady just talks and talks and talks in circles and can't answer a question concisely at all. But let's get to the update hearing, which I've only watched a little bit of, but so far is way crazier than the first one.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Mark A. Carter. It's case number 2023 CR 194. Mr. Carter appears still representing himself in the case. Amber Norris appears on behalf of the state of Kansas. This matter last came before the court on August the 22nd. At that time, the court established pretrial conference and jury trial dates, with the pretrial conference obviously for today. Jury trial was set to begin October 3rd at 9 o'clock. At that time, Mr. Carter argued an oral motion to dismiss based on insufficiency of evidence. Court denied that motion. Court also denied a request for return of a toolbox and welder. Ms. Norris had asserted to the court that this was being held as evidence in the case or on good faith suspicion of theft. The court ordered the county attorney's office to provide an affidavit supporting the search warrant from April the 5th of 23 by email within 7 days. The defendant was again informed by the court of his need for retained or appointed counsel rather than representing himself. The court noting that he was still desiring to proceed pro se. Ms. Norris was to draft a continuance order. Since then, there's been 2 motions filed, which we'll address today. One is entitled Defendant's Motion to have Assistant County Amber R. Norris held in criminal contempt.
Did he seriously just say criminal charges against the prosecutor?
And affidavit. The other, motion for transcript of court proceedings held on Zoom. Are you still wanting to pursue a contempt citation here, Mr. Carter?
Your Honor, she was not complying with your order. That was my only way to bring it to the court's attention that I know of. So she has complied with the order since, but it was way late, and she did not email it when she did comply on the lateness of the original uploading of the document to the DocuShare website. And it only after the motion I filed was the email sent to me.
All right, Ms. Norris, do you want to address that?
Sure, Your Honor. The court had ordered that we comply within 7 days. When I returned to my office and I went through our file, we actually did not, we had the search warrant, but we did not have the affidavit and application. So we had to request that from law enforcement. They did not. We requested it several times over the course of the 7 days, and we did not receive it until I believe the 13th. And that's the day that we sent it through DocuShare, and the defendant opened it, downloaded it. And because we could see when he looks at anything and when he downloads things from that program. And I think since it took longer, obviously, because we had to wait for law enforcement to provide it to us. And then the motion was filed after it had already been uploaded to DocuShare, after he had already had access to it, and after he had already repeatedly emailed me regarding same. Then he filed the motion for contempt. So he actually had it But I think in our office, there was a little bit of confusion. We normally send discovery through DocuShare. And so when we got the affidavit and application, it was sent the normal way we do discovery, instead of specifically by email. And then once I realized that it hadn't officially been sent by email, but that he had already had access to it, I did go ahead and send it by email to be in compliance with the court's order. But I think that was just really an oversight. But the reason that it was longer than 7 days is because I could not produce what I did not have.
All right. The court is prepared to rule on the contempt motion that was filed by Mr. Carter. First of all, it would not appear to the court, at least from the content of the file before me, that Ms. Norris was ever properly served by the sheriff with the contempt citation as Kansas law requires.
It's a good thing it's Judge Ricky hearing this case, and he has that stoic, straight business appearance, because I think most other judges would have laughed and had a hard time covering it up. But he didn't even bother to serve her. Come on. I thought you were an expert pro se.
Further, the motion in this case is not really one based in criminal contempt, but rather civil contempt. And because it's meant to try to compel compliance with a court order, the remedy that the court would be seeking would be to try to compel compliance and try to take steps to compel compliance. The county attorney's office is already compliant. Furthermore, the 7-day order was more directory in nature than mandatory. It presupposed that the county attorney's office was in possession of the affidavit. They apparently weren't. It does appear that the county attorney's office took reasonable steps to comply with the court's order anyway. And even on its merits, the motion fails. So at this time, the court will deny the motion to hold Amber Norris in criminal contempt for the reasons stated. And we'll move on to the next motion, which is before the court, a motion for transcripts of court proceedings held on Zoom. Mr. Carter, I note this wasn't even filed until September the 14th. You're requesting transcripts of a preliminary hearing, which took place in July. Further, your motion for transcripts, I think for the first time, is making the allegation that you are indigent. You've never submitted a financial affidavit which sets forth your financial assets to let this court make a determination whether you're indigent or not. But even presupposing that you are, this is a very belated request. We are set for trial next week. And you didn't file a motion for these transcripts, which you claim are critical to your defense, until September the 14th. Which I find curious, to say the least. Furthermore, without having made a prior finding of indigency and without a financial affidavit, I'm in no position to be able to determine that you can't afford them. I mean, when these hearings were over, you could have made a request to court administration for a transcript of this, received an estimate of cost. Did you do that?
Yes, sir, Your Honor, I did.
All right. What was the estimate of cost?
Several $100 per hearing. Several $100 per hearing.
Several hundred dollars. Okay. Obviously, unless you are found indigent by the court, you have to pay for that yourself. Furthermore, I'm not currently aware, nor am I aware exactly what your theory of defense is. That will obviously come out at trial, I think, but I don't know that they're necessarily critical to your defense. Further, you made a request for a hearing that wasn't even evidentiary, saying that you think that that was critical to your defense. It's difficult for this court to understand how a non-evidentiary hearing and the transcript of that would somehow be critical to a trial defense. Can you fill the gap on that one, Mr. Carter?
Yes, sir, Your Honor. It was statements made by the defense. I mean, not by the defense, but by the prosecuting attorney, Ms. Norris, as to hold her to what was actually said in court on the ruling and your ruling as well for the return of my items of my welder and my toolbox.
So just to explain that one real quick, he stole everything from his former employers saying that they asked him to store the items for them and then never picked them up, and then they owed him money and then all these different things, and then he didn't do it. He has 20 different defenses, but in return, he's saying that they have a welder that belongs to him in a toolbox and he wants those back. And he is very adamant that he wants those back. And that is what he's referring to, is the things that he wants back, you know, regardless of what he actually took of theirs.
Where I feel like it is, I don't feel like you've remained impartial with this, with that section of this case, Your Honor. Respectfully here, I feel like you're biased in a way, because I know that you worked with Ms. Norris, and as you even stated so in your finding of that ruling, that you've never known her to lie or whatnot. I can't remember exactly how you worded it, but it was along those lines. And you said on that alone that you're gonna let her hold the items from me to continue, even though I have evidence that she has the evidence that clearly shows by the photos that those toolboxes and the welder has never been their items to begin with, and they never owned them. They weren't in any possession of them at any time. The Snap-on toolbox, he's never even had it at his shop to even consider it be his.
All right. Identity of the ownership of those items. Can you mute yourself again for a minute, Mr. Carter? All right. The ownership of those items may indeed be an issue for trial. However, Ms. Norris will not be a witness. Her statements are not going to be held as evidence in court. So anything she said during the motions hearing isn't really going to be relevant for purposes of the trial. Determination of that ownership issue has to be based on evidence that's presented there. And I can assure you that Ms. Norris will not be a witness. So again, it wouldn't appear that there is a legitimate issue stemming from that motions hearing where there's even a colorable claim that you're entitled to a transcript. Further, the court, even if you're determined to be indigent, which this court has not made such a finding, Mr. Carter, because you've never submitted a financial affidavit, and I kind of getting the impression that you don't want to.
Your Honor, may I say something here? I was going off of what you had, and that's why I've inquired so much about whoever filled out the paperwork or had it applied for me to have the attorney at trial. And
the court made that determination on its own.
I understand that. And that's why I come to find that out. And that's what I was wondering, is how they became how it was found that, because it stated that I was found to be indigent for that process to happen. That's what I was going off of, Your Honor.
All right, if you'll mute yourself again. Okay. That determination was not based on indigency at all, Mr. Carter. That was made based on this court's determination that you may indeed need access to legal counsel. We're going to go over that a little bit more here in a bit, Mr. Carter. But again, that was not based on an indigency finding. It was based on this court's determination there was a need, independent of indigency.
I was just going off of what it said in the order, Your Honor. It just had that stated on the order, that's all.
Well, yeah, that's a boilerplate order that BIDS uses. Sometimes there aren't enough boxes on there to check. But I do wish to clarify that point. It was certainly not based on any determination regarding your financial condition, Mr. Carter.
And that's where I was just confused on how the court was able to find that out and make that determination, because that's all I could read on there was that box was checked. That's where I got that basis from. I'm not saying that I've filled any affidavit out for that. I'm not claiming any of that. I'm just going off of what I read that the court had found in my ruling or on the ruling for me to have the attorney present at trial. That's all, Your Honor. That's
all right. And that's fair enough, Mr. Carter. Again, it was on a BIDS form. Generally, these appointments are based on indigency, but in your unique case, it was not. But that form is what's required by BIDS. So that's what it was submitted on. Further, Mr. Carter, I think this is the proper time to address certain matters. From the very inception of this case, Mr. Carter, you've insisted on representing yourself. And there's a number of advisories I'm going to go ahead and give you at this time. I have advised you all along that you could change your mind and either retain counsel, or if determined to be indigent, you can have counsel appointed to represent you, and you can petition the court for appointment of counsel to assist with your defense. And I do want to make sure that you're aware, even though this court has appointed standby counsel, that once the trial starts, that no postponement of that trial will be permitted for a more active role by an attorney, including your court-appointed attorney who's operating on standby. That at some point during the trial, the court does have the discretion to terminate self-representation if you, the defendant, deliberately engages in serious or obstructionist misconduct before the court in that trial or any proceeding in this court. That the court, once again, I'll inform you, Mr. Carter, that I consider it detrimental for you, the defendant, not to accept or employ counsel to represent you. Even when you were asked for a delay of this morning's hearing so that Chris Pate, your standby counsel, could attend, you rejected that notion. And I understand that you wish to represent yourself and that you have a right to do so. But I think Mr. Pate did want to be part of this, just to know what was going on with the case, since he's being asked to stand by next week. But nevertheless, you wanted to go forward with this hearing at 9 o'clock, and we have done so. Again, I think self-representation is not in your best interest. That if you are allowed to represent yourself, which at this point you are, you must follow all legal rules applicable to the trial of a criminal action. That there's a number of dangers and disadvantages to self-representation, including the following things. That the law provides for numerous pretrial motions available to you, which are of a technical nature, the advantage of which you would lose if allowed to represent yourself. For example, you filed a criminal contempt motion, you didn't know how to serve it, and you didn't even couch it in proper contempt terms because you sought a criminal contempt, and clearly what the remedy you were seeking had nothing to do with criminal contempt. That's just one example that counsel can help you with when it comes to these legal issues. I'll point out to you that your vocabulary and lack of legal training may impede clear communication with the court and opposing counsel. I'll inform you, Mr. Carter, the judges will not act on behalf of a defendant in asserting objections or making appropriate motions, where ordinarily it is the duty of counsel to call such matters to the court's attention. The county attorney, Ms. Norris, will not assist in the defense of your case. I'll point out to you that the rules of law are highly technical and will not be set aside in view of your status. And that you, as a defendant in a criminal case, may waive constitutional, statutory, or common law rights unknowingly. I need to point out to you, if this hasn't been pointed out to you clearly before, that the maximum sentence for this offense is 17 months in prison. The sentencing range under the guidelines for a level 9 felony with which you are charged is 5 to 17 months based on criminal history, and that you also face up to a $100,000 fine for this offense. So I want to make sure that you realize the possible penalties that can be imposed if you go ahead, represent yourself, and are convicted. Further, the court did appoint standby counsel, a very experienced and very good trial attorney, Christopher Pate. His role is limited. Since you've asserted a right to self-representation, Mr. Carter, he is only there for the purpose of giving advice to you if you expressly request it. He will sit near you during the trial, but he will not participate without the express request of you, or perhaps as directed by the court. But I would have to first then determine, before I get involved in that, that you are not competent or qualified to continue with your own defense. Do you have any questions about what we've gone over here, Mr. Carter? Did you understand clearly all of the points that the court has made?
Your Honor, I do and I don't. I have concerns. I have many concerns here. First of all, the attorney that you have appointed for standby, We have been communicating, and in our communications, it is my understanding that that I understand that he is there for limited capacity, and he's there for just the legal procedure advice, which I've asked him for, which then he gives opinions, and then he repeats what he's supposed to be there for. I've only gotten opinions from him, and not so much as procedural advice or help with the procedural stuff that I've asked him so far. I don't feel like he's there for I don't feel like he's there for me to help me in any way other than he said that I have to prove my innocence, basically. That's exactly what he said in his email. He said, I have to prove to the jury that I didn't do that, and that the bishops are lying. And then he states right after that, he said, well, actually it's the court's or the prosecuting job to to prove that you're guilty beyond a reasonable doubt. So he's more of an opinionated person to me than he is helping with the procedural. He's weighing in on facts or disputes in the case of evidence or whatnot. And I'm not asking him about that. I'm asking him procedural and legal advice for how to proceed or how to file something. And I'm not getting the response back that I need, or even anything remotely close to that, Your Honor. I don't know if there's any other standby counsel. I understand, but it's limited to the capacity where it's not opinionated, though, right? I don't need he's not there to give opinions and legal opinions. That's not what I'm asking him for.
Okay. If you mute yourself for a moment. All right, Mr. Carter, his role is quite limited. You're representing yourself in the case. His duty is really at trial. It is at the trial proceeding that I want him available as someone who can be accessed by you to provide advice either on procedure or maybe even substance during the course of the trial. As far as being a pretrial resource for legal information or advice, that wasn't his role. I'm glad you two could communicate. That certainly doesn't bother me that you've communicated. But again, you have asserted self-representation. And if you don't wish to rely on anything he said, so be it. You can consider it, reject it. He does not have a role in actively representing you or advising you until time of trial. And I just hope you understand that. He's really only there to be trial standby counsel at this point.
Okay, Your Honor. Well, that's not what he was. He portrayed to me that at that point that he was appointed and by you or the court, that his role was from that point on to assist with me with procedural if needed. He said, I understand that you represent yourself, but I'm here as legal advice or procedural advice on how to proceed all the way from then till through trial and sentencing is what he said. That's what he told me.
All right. So I'm not sure what your ultimate point is here. Please clarify.
Okay, you just stated that he wasn't here for that until trial, but I'm just saying that's why I was asking him what I was asking him, because he made it seem as if he was in that capacity at that moment, not just at trial, is what he portrayed to me. So I'm under the belief, I'm being told one thing, you're telling me something else. He's telling me one thing and he's not giving me the procedural advice or how to proceed or how to file. I'm asking for motional support to file, and you're saying that he's not even supposed to be doing that right now. I understand that, but I'm not expecting. Okay, well, I'm just saying that's what he said that he was there for that as of then. I asked him, I didn't get the response back. I got nothing but mainly his perspective on things and what he weighed in on legal stuff. And I'm not asking him to do that. I was just seeing if he was trying to help me or not on procedural wise. That's all. And I don't feel like he's there for that. I feel like it'll be the same way through trial with him for some reason.
Court's not inclined to change its previous order regarding Chris Pate's role as standby counsel.
And Your Honor, just so the court is aware, once we got the appointment, we did forward discovery, and any further discovery that has come in, and also generally Mr. Carter emails quite frequently. And when I reply, if I do reply, Mr. Pate has been on the emails so that at least he's aware of what's going on. To what benefit that is to anyone.
All right, Ms. Norris, let me ask you, has there been any attempt for you to communicate with Mr. Carter to try to resolve this case in any way? It's a question I generally ask counsel at times.
Your Honor, no, there has not, but Mr. Carter has not really put himself in a position, or his emails, etc., do not lead me to believe that he has any interest whatsoever in taking care of this case in any other fashion than to go to trial. I don't. That's just the impression I get from the emails and the and obviously the motions that he's filed. And there is a motion in limine that I filed yesterday, Judge. It did get filed with just where I emailed a copy to the defendant, and then I emailed a copy to you and your AA this morning on the off chance that you had just not seen it in the just where queue.
Maybe
anyway,
will produce that for me here momentarily.
And so, Your Honor, if you wanted to ask Mr. Carter about the possibility of resolving the case, I just have never gotten the impression that he's even remotely interested. So I would say that discussion has never occurred.
All right. I'm going to take a 5-minute recess at this time. We're going to put you two in a breakout session. And I want you two to at least discuss the possibility of it.
Yes, Your Honor.
We'll come back on in 5 minutes. If you need more time, perhaps the court will extend the conference time. But I want you two to at least have had the opportunity to talk, as is traditional, as part of this pretrial conference docket. So I'm going to go ahead and stop recording and broadcasting at this. Following a recess to allow a conversation between Mark Carter representing himself and prosecuting attorney Amber Norris, the court resumes proceedings in case number 2023 CR 194. I'll also note that Chris Pate, who's the standby counsel for trial purposes only that the court appointed, has now joined the meeting. Ms. Norris, following this opportunity to discuss possible case resolution with Mr. Carter, what would you announce at this point?
Your Honor, that there is, and probably won't ever be, a chance, really, I don't think, for this case to be resolved outside of a trial situation. We had some discussions and we had a hard time staying on topic. But yeah, I don't think that there's any way that there will be any kind of a plea in this matter to the point where the defendant is, talking about civil action after this case.
All right. There are a couple of motions still before the court at this pretrial conference that the court needs to address. Mr. Carter, your motion for transcript of court proceedings held on Zoom. Number one, as the court referred to earlier, there's never been a finding of indigency. So as far as your claim that you can't afford the transcripts, the court doesn't have any information before it to verify that.
Can I say something, Your Honor?
Go ahead.
Okay, I'm going to say that I already had the paperwork filled out to file. I just can't drive over there. It's a lot of gas from Viola area to El Dorado, of course. That's a pretty good long distance away from me to drive over there to file the paperwork and then leave and come straight back. I did not file since the order was for Chris to be my attorney because of, like I explained earlier, the indigent thing was attached to the order that you made, and where it was, the box was checked off for that, and I assumed that that was the way it was going to go for, and that I could be found for that to get the transcripts at this point. And it was a mere obvious misunderstanding of what the judge, of what you had ordered, and the boxes checked and whatnot, finding the indigent, but it's actually not found indigent. I can attest to you here today, any financial statements that you would require for me to fill out on form, I could, under oath, whatever you need me to do. But I can attest to that I am an indigent defendant at this point, that I cannot afford the amounts or anything close to that for the transcripts, but I desperately do need these transcripts for trial due to the fact that they do have the testimony of the 3 witnesses that the state has brought forth to get this action and keep it going to trial. And in those testimony, the officer Scheinert has perjured himself several times on several notes, clearly on from things that Ms. Norris has asked him and things that I have asked him. His responses, and I've clarified it with him 2 to 3 times during that testimony of his answer, and my ring video clearly are in total 100% contradiction to what he has stated on as far as letting the Tim and Kim Bishop search through my stuff or assist in the search. He's testified that they were not there to, they didn't assist in anything. They didn't search through anything. He testified that he was there and searching and that they were looking over his shoulder. Now, the ring video that I've submitted to Ms. Norris, she's got it. It does show that the Tim Bishop, Kim Bishop searching through my stuff without the police even in the presence of them like there. You can just hear them in the background to the side. They're not searching through anything, but Tim and Kim are. And if anything, it shows that the police are looking over Tim and Kim's shoulder as they're searching. That's just one thing. There's obviously Kim or Kim has taken videos and taken pictures on her iPad. He testified, Scheinert testified that she did not take any photos there. She wasn't allowed to have an iPad or anything, only to show him pictures. Tim has testified that she didn't take pictures, and Kim testified she didn't take pictures. Now we have the email chain.
Okay, so not only is he a wackadoo, but he's got a bad memory, because she specifically said she took pictures and compared them later. I remember that from months ago when I watched it, and I could rewatch it and clip that if, he needed me to.
Where Scheinert is getting and requested the photos that she took, and we're waiting on those photos now. He's admitted to it, and so is Kim.
Mr. Carter, these witnesses would have to testify all over again at the trial. If you have some sort of evidence to challenge the credibility of their statements, you can present that at trial, can't you?
Yes, Your Honor, I can, if they state the same thing they testified to in the first one. But if they change their testimony at the trial to exactly what the video shows, that doesn't show my perjury, which I have it on. If we have the transcripts, it will clearly show contradictory 1,000% to everything that actually happened. They didn't know I had ring video, obviously. It has ring and it has audio and video, and it rolls 2-minute clips at a time. Every time there was a motion, and it pretty much, it doesn't skip a beat through any of it for the good portion that anybody's up there close to the camera. I have every bit of it, like the entire day, that whole afternoon, all the way up till almost midnight, to where they're there going through the stuff, and it goes against everything that he claimed and they claimed in testimony before you in the court. Under oath, Your Honor. It's clear as day.
I'm not aware of any authority that absolutely requires a preliminary hearing transcript to be prepared. Court can consider alternatives to preparation of transcripts. I can set up giving you access to the Zoom record on Monday afternoon if you so desire.
Oh, that would be great.
You'd have to come to the Butler County Judicial Center here in El Dorado.
Oh, and Judge, I wasn't aware that you actually still had those.
Excuse me?
I wasn't aware that you were actually keeping the video.
Yes. Well, yes, we are. It should be available.
That'd be more than I could ever ask for, Your Honor.
All right. What time would I tell them that you're going to be here? I think that's probably a couple of hours, 2 or 3 hours worth of testimony total. Can you be here at 1 o'clock?
I could be there in that morning.
All right. What time in the morning?
10 o'clock.
All right. We'll have somebody contact you by email if that won't work. You'll have to go to the place in the judicial center that's designated for you. Obviously, I'll expect you to take care of any equipment that the court is using to display the Zoom recording. So I'm not going to allow any substitute video be introduced at the trial. So just in case you're thinking about recording what's on screen, you could do so, I suppose, for your own purposes, but it's not going to be admissible at trial. The only recording that would be admissible would be the Zoom recording itself. And then even then, you'd have to meet certain requirements as to whether that's even proper or not under the circumstances of the case. I'll reserve ruling on that. But I'll try to set up at 10 o'clock on Monday to have you get access to the preliminary hearing record. All right. With that dealt with. If you mute yourself,
I just have a few questions, Your Honor, about the evidence in the trial on introduction of it. And I understand proper procedure and everything. I don't understand why it wouldn't be allowed for me to introduce during questioning of a witness of the state, should I say, at this point, a witness of the state, of their actual being recorded on my Ring camera and things they're saying, and it shows their picture of them, and have them testify as to that video being accurate description and representation of them in that day and what they're saying. Are you saying there's no way I can actually have that brought into evidence?
I didn't say that at all. I was talking about the Zoom recording video. That's what I was saying.
I understand. Okay.
Not some independent video that might be determined relevant. No, I haven't ruled on that.
Okay, that's all. Thank you.
All right. The motion in limine filed by the state still needs to be addressed. What they're attempting to limit is that apparently defendant filed a PFS, a protection from stalking action, against the bishops, who are, I think, the alleged victims and will be witnesses at the trial. Apparently, they haven't even gone to final hearing yet. State's position is any information regarding these PFS cases would not be relevant and would not be material to any issue in the trial. And they're objecting to any reference to the existence of a PFS case. And apparently that's a Sedgwick County case.
Your Honor, they keep coming out here to my residence all hours of the day and night, making noise and ruckus, harassing me and my family. And I filed a PFA.
What does that have?
We had the hearing. Well, the thing of it is a character flaw, because their characters at question when they're on the stand, Your Honor. When they're giving testimony, their characters at 100% question. This is a part of that file of their character. Their character is they're coming from Andover, Butler County, a separate county from here, all the way to the far extreme southwest corner of Sedgwick County, just to drive around my place and harass me and my family at all hours of the night and day. Tim even admitted it to the judge, and the judge in that court actually found it enough to keep that order to remain in effect for them not to come out here and harass me anymore, Your Honor. It is an order, and the judge only continued it till after the trial of this matter here is taken care of. And he didn't know the exact date, and he didn't know how long, he knows, I guess he had experience with Butler County's trial dockets taken and sometimes extending out longer than they had been because of the COVID-19 issues going on. And he wasn't aware of anything changing since then and how it was going right now, to the effect that he didn't know exactly when the trial would actually commence and be finished. And so he gave it a little bit of a leeway with the November date of the hearing actually being held, but he did take into account the evidence that I submitted and showed him. Tim admitted that it was him on the video, of all the videos I showed him, and the judge made his ruling.
The problem is the ultimate issue for the jury to decide is your guilt or innocence regarding felony theft. Their behavior toward you subsequent to the filing of these charges, I don't see the relevance at all. Carter,
They're
all
victims.
we can do is get distracted on side issues that have nothing to do with the issues that are really there for trial.
Your Honor,
Nothing you've said has convinced the court that the motion in limine should not be granted. I don't want to
Your Honor,
protection orders.
Your Honor, may I say something else here?
You may.
The reason it should not be excluded from this due to the fact that that is a character issue. If they're alleged victims in a case that is proceeding before the jury right then, the jury has the right to know the character and the actions of those people that are portraying to be a victim in a case that is trying to get me put in jail or fined and all this other stuff, found me guilty of a felony. So their characters at play here. They're out here harassing me. It has been found and extended to go into and remains in effect. It says it right here on the order. Remains in effect, Your Honor. Both of them, both cases. Kim and Tim separately filed. I filed separate ones because of their harassment to me. Now, it should be allowed that their character come up in court. And it is my right to bring their character up against any witness the state
Wait a
brings forth.
minute. If you're going to say it's your right. What is the authority behind that statement?
My constitutional right to have to question witnesses before me and their character, Your Honor.
Character evidence in Kansas is limited by statute to only certain instances the character can be brought up. We don't try cases based on the character.
I'm not asking you to. But the victim's character in the case where they're claiming to be victims in a matter before the court, claiming that I have stolen something from them, whenever there's evidence that shows that I have not, and their character where they have actually perjured themselves, which I will be able to prove, their character will all be at the show of the court and to the jury. If they've perjured themselves, and I can prove it in the court by the testimony that they've given already and what they say in court that day. It just depends on what they say that day but it'll be perjury either way because of the records that the officer's got in his notes with my ring videos that I can introduce. It's there, Your Honor. The case will not proceed. The victims, the alleged victims in this case are lying. I do have the evidence of that. They have came out here, harassed me and my family at all hours of the day and night. That should be allowed in this case, especially make the determination at that time is what all I'm asking you, Your Honor. After, I won't even introduce it until after I've shown the perjury and laid my foundation for my case. I'll introduce it at the right time after that, and you can make that determination then. Can I ask you to do that, Your Honor?
I don't want any references made to this during jury questioning, during opening statement, or any other part.
The end of the video got cut off a little bit, but there was nothing else said that was super important other than you're going to trial. I'm not granting your motions. And he tried to get him to stop. So this was a couple days ago. It was just right at the end of last week, and it gets even better. He filed a motion yesterday. Trial's supposed to start today. Trial's supposed to start on the 3rd. He filed the motion on the 2nd. The motion to dismiss, motion to suppress evidence, motion to return seized property, which is his welder, motion to request a change of judge, statement of facts, and affidavit of memorandum. Like, what on earth, dude? There's just so much that I'm not even going to go through this whole thing. It's laughable, and I'm sure they'll have a hearing on it, and we'll cover it there. If you want to look it up, you can look it up on the Kansas court records and just search for Mark Carter and refine it by Judge Ricke's name, Ricke. Yeah. To be continued.